A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. Yeah, should I do it again, Jose? Yeah, I got it, huh? All right. Shall not be infringed. Okay, I'm looking here, trying to get on Facebook so I can get the show on the road.
It's a little slow right now, but it should be on now.
Okay, I got it. So here we are on Facebook. So post away out there, tailgaters. So here we are on a Wednesday afternoon, starting out with Jemmy Cudney. Once again, we have a news article masquerading as an editorial. Our View, 1950 census provides insight into post-war Guam. That's it. That's all you need to say about the whole editorial.
It's informative, but not an editorial.
No, it's not. Yeah. So, yeah, if you want to do some interesting reading, take a look at the 1950 census from Guam. Don't waste your time on this, though, however, because there isn't much to read about. Okay, let's go straight to Zemi, as you were, straight to the card. And this is what I got on the card for today. I've got Paul Zerzan versus systemic racism. Paul Zerzan versus the Department of Labor. I've got the Guam Bar Association versus traffic on West O'Brien Drive. Gov Guam versus land. And kind of along the same lines, Andrew Santos versus the Waterworks and Cortec. And then some stuff that's been on the card for a long time, like Democrats versus Ted Cruz, Tall Tales versus Ketanji Brown Jackson. So things dealing with the Supreme Court nominee that I haven't gotten a chance to get to yet, but I will probably be able to today because we've got kind of a thin card here at the beginning. So Paul Zerzan, systemic racism. You remember Paul kind of made a name for himself here on Tall Tales by coming forward and telling people that the stuff that they eat at fiestas that they call red rice isn't really red. This is what I mean. You look at this. Paul said that rice that you call red rice is not red, it's orange. So why don't we start calling it by what it really is instead of red rice? Well, not long after that, the Daily News wrote a nice little editorial piece saying, let's see here, readers to Zerzan, leave our red rice alone. So I've used this as an example of the difference between the narrative and the facts. The facts are that the rice that we serve at fiestas is not red, it's orange. The narrative is we've been calling it red rice ever since. Everybody calls it red rice. Everybody knows it's red rice. Who in the heck is Paul Zerzan to come along and tell us that our red rice is orange? In other words, the narrative is forget about what color it really is. It's orange. That's why I wear my red shirt every day. You might think it's orange, but Jose and I'll tell you, no, according to the narrative, it's red. And we see that just over and over again here when we're examining the social construct of our island and our country and the politics of our island and the country, that there's a narrative that cannot be contradicted on pain of cancellation or worse. So Paul Zerzan is the guy that came out and said, hey, no, it's not red, it's orange. And then we had a gentleman named, let's see, I forget the name.
Farron
Tyron, who said, you know, the Guam flag the seal in the middle of the Guam flag that is the picture of a canoe? Well, it's wrong, because anybody who knows about sailing will tell you that that boat would never sail, and has been wrong since 1917. So I suspect there are those out there in the community mumbling the narrative, that's been our flag. That's been our flag ever since. Who is this guy Farron to come along and tell us that our flag is wrong? And of course, the governor's office is taking dramatic action. They're studying the issue. And as Jose pointed out the other day, if anyone should be concerned, it should be the lieutenant governor, who, according to the Organic Act, is the keeper of the Guam seal. There was a third person that right along here with the systemic racism was Elwin Champaco Quitano, who wrote a letter to the editor of the Post saying that, all this stuff about indigenous Chamorros, etc., is hokum. That the island was populated as much as anything, and probably a lot more, by migrants from the islands south of us. And of course, this will cause a firestorm of conflict. Every possible ad hominem attack in the book will be thrown at Elwin for that. How dare he? And then Paul Zerzan, of course, came forward and wrote a letter to the editor of the Daily News saying that he's noticed, or maybe it was the Post, he noticed that there were 3 claims for eye injury coming from Cortec. And according to his own experience, that's pretty unusual. 3 eye injury cases from one in a 4-month period from the same company. So he decided he needed to do something about that on the basis of see something, say something. So he went next door to his office, to the Office of Safety and Health Administration, OSHA, and told them his story, gave them the file numbers, etc. Well, less than an hour later, OSHA ratted him out to his boss at Department of Labor. He was called on the carpet, given a Class A ass chewing, told in no uncertain terms that his boss is a political appointee, that would be the Director of Labor, David Del Isola, and that politics in an election season is more important than safety, and that he shouldn't do what he did, and that he better not do it again. The next day, he came to work and was assigned as a paper shredder technician instead of his regular duties. Probably a promotion, huh? Running those shredders is high-tech stuff. And then in the afternoon, he was sent home, and the next day he was told he was terminated. So today, as you were in the 4th of April, he got a letter of termination over the signature of Dorothy G. Gutierrez, Program Administrator, which he sent to me. And I'm going to read it. And it says, Dear Mr. Zerzan, and the subject is the SCSEP program, whatever that is. Dear Mr. Zerzan, half a day. Starts out nice and friendly, right? This is a formal notice to terminate your enrollment from the Senior Community Service Employment Program, SCSEP, for cause is identified on page 22 of the SCSEP handbook, in which you received on September 14, 2021. As a result of the situation that occurred on March 24 at your host agency, Guam Department of Labor Workers' Compensation Division. The effective date of your termination is March 30, 2022. Your types of termination, number 6, termination as you were, termination for cause under non-IEP related issues. Boy, if you want to get fired by these guys, you better go to law school first.
Am I getting paid for this firing? It's taken a couple of days.
Yeah. Related reasons, we have identified bullet number 4 as a justification for your termination. Intentional disclosure of confidential or private information obtained from the host agency, grantee, or local project, for example, informing others of information that is supposed to be kept private or confidential. Well, okay, now this assumes that the information that Zerzan disclosed was private or confidential, which this letter doesn't address. Too busy with abbreviations, and etc. If you disagree with this termination, you have 10 business days from the postmark date of this letter to make an appeal. Appeals and or grievances can be made to the Director of Labor, David M. Del Isola. However, we highly encourage you to come into our office to discuss what other services may be available to you through the American Job Center. We can assist you in continuing your job search and assist with your resume. Please call us at 475-7000 to schedule an appointment, or if you have any questions. You may also visit our website at www.hireguam.com. I wonder if there is a section on hireguam.com dealing with termination for cause.
Recently terminated by us.
Yeah, by us.
That's kind of circular, though, huh?
It is. Recently terminated by us, but we do have jobs available. So, the question that comes to my mind then is the information that Paul Zerzan gave to OSHA confidential or private information? And if so, I'd kind of like to see your bibliography on that one. That's my lawyer's instinct talking, that so often when someone angers a boss, the idea, let's fire that guy. Yeah, okay, we got to fire him right away. Do we have any grounds? Oh, yeah, right. Yeah, find something. Yeah, got to get him out of here. So Paul Zerzan writes an appeal on April 6th, which is today, which he gave me a copy of. And it's to David M. Del Isola, Director, he says, Director of Department of Labor. And let me see yeah. And, of course, he's not the Director of the Department of Labor. He is the Director of Labor. Dear Director, I wish to make an appeal concerning my job termination. I enclose a copy of the letter of termination dated 4 April 2022. On Wednesday, March 23, I became concerned about eye safety at Cortec based on information I came across in my job duties at workers' comp. Specifically, 3 injuries involving foreign objects in the eye occurred in a 4-month period. These are case numbers 202-100-1874 on September 7, 2021, 20220000468 on January 3, 2022, 20220000510 on 1/13/22. I took my safety concern to Guam OSHA. On Friday, April 25, I was reprimanded for this. On Wednesday, March 30, I was verbally fired, and I received the letter of termination on Tuesday, April 5. My concern was job safety at Cortec. Does this information harm anyone? Does it really need to be kept private or confidential? If so, isn't job termination too harsh? Couldn't I receive a few days job suspension without my pay and or be transferred to another job posting? Paul Zerzan. Well, if he's right, then he doesn't want a suspension. If he's wrong, he's wrong. And of course, the question to me is, what documentation could the Director of Labor come forward with to show that the information in those case numbers is private and or confidential? And of course, the two are not the same thing, private or confidential. So going back to Garcetti versus, what was the guy's name? Started with a P. It wasn't Padua, something like that. If Paul Zerzan went public with something concerning his own job grievance, his own bitch, so to speak, then what he said is not protected speech. If Paul Zerzan went forward with something that is arguably in the public interest, then it is. However, the other side of it is that, at least as far as I can tell from here, being employed under the Senior Community Service Employment Program does not give rise to an expectation of termination for cause, although that's exactly what's mentioned here. Yeah, Sabalo, yeah. So, you know, there's some interesting questions here because, you know, if the employee is a at-will employee, you can fire him for a good reason or you can fire him for no reason at all. But you can't fire him for a bad reason. So taking the rule from Sabalos, saying that if an employee is speaking out about his own employment grievance bitch, so to speak, not protected speech, but speaking about the operation of the government in general, arguably in the public interest, potentially protected speech. So I'm very interested to see how this goes for Paul Zerzan. I'm going to be the great Karnak here for a moment. Sorry about that, Mr. Zerzan. Appeal denied.
Denied.
Yeah.
You know what's interesting though, Bob, is we're watching this in the context of free speech or First Amendment.
Yeah.
But the initial reason why he went forward is because of damages or workman's comp, which is another greater kind of issue in the government of too many cases, or is there something happening at the site?
Yeah.
So I'm wondering if that gets set aside and the focus is on, you know, these numbers or letters that he put out there.
Well, of course, we can see what management's approach is. Now, some folks out there in our international radio listening audience are going to say, you know, had Zerzan gone to his supervisor and said, hey, I've seen this. This doesn't look good. Should we bring it to OSHA? And if the supervisor says, shut up and go back to work, it's what we, in the Marine Corps, what we call request mast. You have the ability to see your commanding officer to raise any kind of complaint that you want. You're not going to be beaten up because you raised the complaint. So Paul could have perhaps done the request mass type of thing and gone all the way to the Director of Labor. I suspect that's what occurs to some folks. But perhaps Paul has tried that before. No success. We don't know. But it's a very interesting dichotomy here. On the one hand, confidentiality, and on the other hand, an employee speaking out concerning something that he sees as a wrong that's not going to harm him, but is going to harm members of the public. And once again, Paul is a hero here on Tall Tales because when he sees something, he darn sure says something, except when he's in the company of Hope Alvarez, which in that case, perhaps his silence and his demeanor spoke even louder than the rantings of Hope Cristobal, which made absolutely no sense at all. So keep us informed on this one, Paul. Okay, next item on the card, of course, is non-compliance with the open government law. Let's take a short break and we'll come back to that.
Half a day. This is Governor Lou Leon Guerrero. Gas prices continue to rise and we are here to help. We have revised Programan Salapi to provide a $300 direct cash assistance payment to most households. We heard your struggle and we hope this relief will help during these difficult times. Applications will be accepted starting Tuesday, March 15, 2022. For more information, visit doa.guam.gov.
This ad is paid for by the Office of the Governor using government funds.
Listen to The Point anytime, anywhere on Odyssey. Odyssey is your new audio home for all the music, news, sports, and podcasts that matter to you. Find your favorite stations like The Point and discover more. Music stations, local and trusted news sources, sports talk and team coverage, plus today's biggest podcasts. Find it all on the Odyssey app. AUDACY.
Welcome back to Tall Tales with Bob Klitzkie, Guam's single voice of reason. Call now, 888-TALK. That's 888-8255.
Okay, here we go again. Public Law 80, as you were 36-34, which is one of the most important pieces of legislation that's been passed a long time when it comes to citizens being able to keep track of their government. We've had a law in place for a long, long time that requires boards and commissions to give 1 week's notice of their meetings and then another notice 2 days before the meetings. And up until last July, the notices were pretty bare bones. The XYZ Commission will be meeting on Friday, the 13th of June at 2 o'clock at Touray in East Agania. And that was all that was required. But 36-34 said you have to put those notices out, but you also have to put the agenda of the meetings, of those meetings in the notice. And not only must you list the agenda, the language of the agenda must be in such terms as to put on notice the readers. In other words, by reading the agenda, you know what's going to be discussed. And this is great. I mine the two newspapers every day and look for these notices, and there's a lot of interesting things in there, some real important show prep material. You can actually tell what these boards and commissions are in the process of doing just by reading those notices. And of course, you can decide if you want to attend instead of seeing a notice and saying to yourself, gosh, I wonder what they're going to be discussing. And because of that requirement, government agencies now can't call meetings and just wing it when they get there. Since you have to put a notice in the paper a week before the meeting, and since you can't take a notice to the Daily News or the Post on the day you want it to run and expect it to run, you got to give them a couple days. So you got to have your notice, your stuff in on 9 days before the meeting, which means that you must decide what you're going to discuss probably 10 days before the meeting. Much more difficult than just winging it, having a meeting and try to figure out what you're going to do then. Because under the new law, you actually, if you're on a board of commission, you actually have to plan ahead. What a novel concept. And I've noticed that what happens is that a lot of the agendas that get published have an item on the agenda called agenda for next meeting. So let's say in the April meeting, they get to the last item and they say, we're going to have a meeting on the first Monday in May. That's how we do our meetings. Let's discuss what we're going to put on the agenda. And they come up with their laundry list of stuff, and they can perhaps pass a motion that says that, or they could perhaps direct the director to add whatever is pertinent to that agenda so that it can get published, because the law says if you don't comply with that agenda requirement, whatever you do at that meeting is void. So you could have 7 items on the agenda, and let's say that item number 6 is the action agenda, where you make a motion to spend, let's say you make a motion to expand the hours of an agency. And you didn't screw up item number 6, you screwed up item number 2. Well, your action on item number 6 is void, and everything else you did during the meeting is void, because the whole thing has to be correct. And every day, almost every day, I run across agendas that are wrong. Starting out today with the Guam Preservation Trust. It's going to have a meeting on Wednesday, April the 13th at 3:30 p.m. And item number 1 is call to order, roll call. Item number 2, approval of the minutes of the March meeting. Item number 3, old business. 3.2, Smithsonian flag ceremony. I don't know what that is, but I suspect anyone who's interested in it does. Item number 4, new business. Item number 5, committee reports. So item number 4, new business. What new business? You don't know. Therefore, everything that they do at their meeting on April 13 is void because they broke the law. You're not putting anyone on notice of anything when you say new business, because what it implies is when we get to item 4, anybody who wants to discuss something we haven't discussed before, bring it up and we'll act on it. Violation. The Southern Soil and Water Conservation District did a similar, committed a similar type error. They get down to item number 5, partner reports. Partner reports A, 36 Guam legislature. So apparently the Southern Soil and Water Conservation District is partners with the 36 Guam legislature.
Aren't we all?
Talk about a marriage made in heaven. University of Guam, Bureau of Statistics and Plans, better referred to as BOSAP. Guam Department of Agriculture, Guam Environmental Protection Agency, Northern Soil and Water Conservation District. So this is North and South getting together. The Civil War is over. NAVFAC Marianas, USDA Natural Resources Conservation Service, USDA Animal and Plant Inspection Service, Wildlife Services. J, USDA United States Forest Service. K, other. OTHER, other.
It doesn't have an acronym yet.
No, other. It's not an acronym.
They.
Yeah, other. So just having that item in there, K, other, just voids the whole thing. Time to wake up out there, you directors that are making the big bucks, and make your agendas comply with the law, or forget about having meetings, because the results are the same. Okay, yesterday I had an item on the card, Guam Bar Association versus West O'Brien Drive traffic, telling you that the Guam Bar Association was having its annual membership meeting on Friday, April 8th, and that from 3 p.m. to 9 p.m., part of West O'Brien Drive and Hagatna would be closed. The part between Father Duenas Drive and Padre Palomo Street would be closed 3 to 9 on Friday. Well, I got a notice from the Bar Association today that says delay that, as you were. They're not going to close off West O'Brien Drive. It seems that there is a storm in the area, and they think that prudence requires that they cancel the annual Bar Association meeting. And they don't want to bump it till the next weekend, because the next weekend is, guess what? Holy Weekend, yeah. So they will tell us later on when the annual Bar Association meeting is going to be and how many streets they're going to block off in order to have it. And I will pass that on to you, of course. Okay, next we've got Government of Guam versus land. And this is something that pops up on Troy's very, very good website, Candid News. I'm not going to go into it because Troy talks in terms of stealing people's land. And when I get into this, you'll see that maybe Troy's pretty good with the rhetoric, but maybe not this time. One, it's kind of hard to steal someone's land. Come along with a couple of pickup trucks and a couple of shovels.
Hey, Bob, that truck over there, isn't that your land in the back?
Yeah. You fill up the truck and drive it away, but you know what? There's a hole there, but the land is still there. Yeah. So what has happened and what can be done is that title to real property can be sold. Now, title has a different meaning than the one you're used to. You're thinking title, well, yeah, I got the title for my car, but if somebody stole it, I just go to RevTax and get another one. That's not what title means here. Our real property law goes back over 1,000 years to feudal England. And it was an extremely complicated system, and much of the complication has flown forward and is part of the law today. So when we talk in terms of fee simple title, the word fee is short for feoffment. Feofment, feoffment. And in order for a tenant to have an interest in land under his lord, you know the term landlord as far as real rentals are concerned, landlord and tenant. It was all the way back to the old feudal days where the feudal lord was the landlord, and everyone who not owned property or rented property or leased it, but held under the landlord, was subject to these various terms, one of which was enfeoffment. So if you were enfeoffed Blackacre, that meant that the Lord said, you work Blackacre, but you owe me certain services as part of our deal for Blackacre. But in order to be enfeoffed with Blackacre, there had to be what's called livery of season, S-E-I-S-N, season. And that's a little bit too deep to get into on this show. I'm just mentioning this stuff to tell you that real property law is pretty complicated. And when you talk about stealing somebody's land, that requires a certain delicacy and explanation. Now, we know we have a recordation system that keeps track of who owns what land. And this, again, was where we used the word land title. So you can, if you know what you're doing, you can go to the Department of Land Management, and thanks to Chris Duenas, we have a very nice computerized system. Chris brought about a 21st century revolution at the Department of Land Management, for which we should all be grateful. So if you start out with the lot and block number or tract index of a piece of real property, you can trace the chain of title. Now, the chain of title means going all the way back to the real original owner, who took a grant probably from some government agency, perhaps a patent from the King or Queen of Spain, and trace the chain of title forward. In other words, every conveyance in that chain of title bringing you down to today. And a good researcher can tell you by researching the chain of title who owns the property, what the encumbrances are in the property. Are there any mortgages, liens, easements, servitudes, etc.? And a good title researcher can then prepare an abstract of title that'll tell you exactly who owns the land under what conditions. Your title companies do this. That's what title companies do. And they're very good at what they do because title insurance companies are not risk insurers. Let's talk about that for a second. An automobile insurance company is a risk insurance. If you sell automobile insurance, you know that your customers are going to get in collisions, what some people call accidents. And you actuarially figure out how much your premiums have to be in order to make your customers who have accidents whole after the accident, or the person make the person to whom your customer is liable whole. So automobile insurance is risk insurance. Title insurance is not risk insurance. They don't issue those policies with the understanding that people are going to come along and challenge the title that you say is good title. They're saying that when we issue you your title insurance, except for any reservations we put in the insurance policy, your title's bulletproof. There's no risk there. So then we have what's called our certificates of title here on the island. And I've talked about this before. Our certificates of title are what's called the Torrens system, Torrens, not related to the familiar Taurus. Torrens was an Australian. He came up with a system in the 19th century, and this was before, almost before typewriters, no computers, no Xerox machines, etc. So the piece of paper called the certificate of title was the not only evidence of the title to that real property, but it was the title. So if you were the registered owner of Blackacre, you could get a certificate of title that says Jose Martinez, fee simple title Jose Martinez, right? And if Jose had a mortgage to the Bank of Guam, in the blanks below the top of the paper, it would say subject to mortgage to Bank of Guam, etc. Now, if Jose wanted to sell Blackacre to me, he and I would have to go to the Department of Land Management with that piece of paper called a certificate of title. Jose would have to surrender it. I would have to fill out some papers and pay a fee. And the deputy registrar of titles would do an abstract of title. And if it, in fact, was a good conveyance, he would issue me a certificate of title. That's the way it's supposed to work. Now, as you can see, the deputy registrar of the certificate of titles has a really hard job. The average lawyer who doesn't do real estate practice would not be able to sit down in that chair and say, let me at it, I can do it, I don't need to study anything. So this brings us to kind of a long route up to the letter that Troy published on Candid News concerning, it's a letter from the Inspector General of the Department of the Interior, and it says that, in pertinent part, our audit disclosed that although Guam made considerable improvements to existing roads and bridges through widening and repaving, Public Works did not adequately plan, design, or control in-house road construction projects, failed to construct 30 major road projects that had priority while constructing other projects that had lower priority, etc. Let's see, the letter goes on to say, our audit further disclosed that the government of Guam took or reserved for its own use private property without legal due process and without landowner compensation. Now, I kind of question the G2 of Harold Bloom, who is the Assistant Inspector General for Audits, when he says, our audit further disclosed that the government of Guam took or reserved for its own use private property without legal due process and without landowner compensation. Well, there is a due process clause in our United States Constitution, which I have right here in front of me. And it said, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. Okay, now it says state, it doesn't say territory. And this is not one of those where you read the word state to mean territory. The reason it applies here is because of the so-called Mink Amendment, which was added to the Organic Act in 1968 by Senator Patsy Mink of Hawaii, that has language that says that the Bill of Rights, with a couple of exceptions, apply in Guam in the same manner that they would in any of the states. Not to mention that there was a Bill of Rights in the Organic Act as drafted in 1950 that had the same kind of language in it. However, this is not really where the action is, because the next sentence in the 14th Amendment says, wait a minute, I got to go to a different section here. I'm looking for the, for the Fifth Amendment. And the Fifth Amendment, and there's a due process clause in the 14th also. The Fifth Amendment then says, which applies to Guam, nor shall private property be taken for public use without just compensation. Now, it doesn't sound like it, but that's a lot different from taking a person's property without giving him procedural due process. We'll take a short break and come back to this right after the break.
Here at Nimitz Towers, we're a large-scale rental complex. We have over 20 employees, and when the pandemic hit, our concerns were people not being able to work, loss of revenue and income, and luckily, due to PPP, we were able to keep all our employees employed, working. We were able to provide services, maintenance, and cleanliness for the building and the operation. Also, the rental assistance program helped us stay solvent during the pandemic and helped us keep the tenants in place.
We're thankful for Congressman San Nicolas advocating for these funds on our behalf in Washington, D.C.
If you have any concerns about any federal issues, feel free to contact your congressman's office.
Thank you for the federal funds. Thank you for the federal funds. Thank you for the federal funds.
Thank you for the federal funds.
Thank you for the federal funds. Thank you for the federal funds.
Paid for with official funds from the Office of Congressman Michael F.Q. San Nicolas.
Okay, so here we are. I noticed a couple people here have been paying really close attention, which I think is a good deal, and posted some, there's some posts here dealing with what they're interested in. And Benidoso Tautau, you know, he's not as modest as I am. Benidoso Tautau. Benidoso Tautau, I know a person who bought property and didn't realize the title deed had a stipulation that he couldn't build a two-story until he tried to get a loan from the bank. I think it's called an incumbency. Encumbrance is the word, an encumbrance. And then Benidoso said, I remember buying property in Colorado and thought you own the land. You don't own the water under it, running through it. Well, that's very possible. And the same people find that out in the western states when they own fee simple to the real property, but find out that that doesn't include the mineral rights underneath, unless the conveyance.
No oil.
Yeah. So somebody finds oil on your land, too bad. And then let's see, there was another one here too. Yeah, Benito Tau, you pay a title company to ensure the title deed is clear. Well, a deed is a deed. It's not a title deed. And a deed is a conveyance. A deed conveys the property from one person to another. And there are different degrees of conveyance. There is, of course, the one that you like the best is a conveyance, a deed transferring the property in fee simple absolute. But anyhow, going back here to the Fifth Amendment and my criticism of the Assistant Inspector General, who talks in terms of further disclosed, took, or reserved for its own use private property without legal due process and without landowner compensation. The Fifth Amendment to the United States Constitution, the last sentence, nor shall private property be taken for public use without just compensation. Well, where does the national government get the power to take private property? And the answer is not in the Constitution. The answer is that it's an incident of sovereignty. Every sovereign has the ability to take property, such property as it may find useful or desirable or whatever, because that's what sovereigns have the power to do. And if it weren't for this clause in the Fifth Amendment, there would be no just compensation. And it doesn't implicate due process, because if taking a private property for public use is an incident of sovereignty, there isn't any property that the owner is being deprived of. And I know that sounds kind of convoluted and backwards, but that's the way it is. So because of the Fifth Amendment, when the government takes your property, they have to pay you just compensation. So this audit report goes on and says that took the property for its own use without legal process and without landowner compensation. These actions were contrary to the Organic Act and the U.S. Constitution. This occurred because Public Works took no action to resolve this matter on a timely basis because of the complex nature of the issue involved, and two, lacked procedures for the timely identification of land needed for roads in order to enter, acquire, or release private land for development. So in other words, what he's saying here is the director of Public Works at the time, I don't remember who it was, but I could find out, said, let's build a road from A to B. And the surveyor goes out and surveys it, says, yeah, that's where we're going to build it. Whose land is it? I don't know. We'll figure that out after we build a road. So now I think what happens here, let me go a little bit farther into this. As a result, Guam residents may have, in certain circumstances, been deprived of their property rights. Also, Guam and the federal government paid $1.1 million, and Guam may have to pay an added $73.3 million in excess costs for acquisition of right-of-way.
Those are easements?
Well, when you build a road, you ordinarily take fee simple to the property, not an easement. When you string a power line across property, quite often that is an easement, because you don't need to own the land underneath the power line in order to build a power line. You need an easement across the realty, right? In addition, Public Works procured goods and services without compensation on authority. This condition occurred because Public Works lacked procedure to ensure compliance with the provision of the Guam procurement law. To correct the conditions noted, we recommend the governor instruct the director of Public Works to develop annual work plans showing how the major road project priorities established in the master transportation plans will be implemented on an annual basis, which means that the governor can't come along and say, forget your list, I want this one over here done. 2, develop procedures to provide management oversight for in-house road projects. 3, develop procedures and document deviation from established road project priorities. And 4, develop procedures to ensure compliance with Guam's procurement law, et cetera, et cetera. So this is what Troy was talking about. My suspicion is that probably most of the condemnations, the inverse condemnations, well, it's not an inverse condemnation until someone files suit, but most of the land that the government took pursuant to the power of eminent domain, even though court procedures weren't complied with, wasn't a whole road, but probably something like the land necessary to widen a road, or to put a shoulder in, or to widen a bridge, or something like that. So I did a little research on this. I found a case that's not controlling, but very interesting nonetheless. And it's called Carl T.C. Gutierrez versus Guam Power Authority, Government of Guam. Yeah, so this would be the Carl, not our Carl or not a Carl, but the Carl. So I'll come to this right after the big halftime show, which is about to start right now. Correct, Jose? 5 seconds? All right.
The Point is KUSG, Hagåtña, Guam, 93.3 FM and 104.3 HD3.
Not ready to call it genocide. I'm Jack Callahan, Fox News. The brutality committed against Ukrainian citizens in Bucha. But Secretary of State Blinken calls it everything else.
What we've seen in Bucha is not the random act of a rogue unit. It's a deliberate campaign to kill, to torture, to rape, to commit atrocities.
Ukraine's President Volodymyr Zelensky calling it war crimes and telling the UN Security Council yesterday the world must punish those responsible. He said some of those lives might have been saved if he'd had more of the weapons he's been asking for. Now the U.S. is sending more.
The Pentagon announcing an additional $100 million in security assistance for Ukraine, including Javelin anti-tank missiles. And a source telling Fox News that the U.S., in coordination with the G7 and the EU, are about to announce an additional sweeping package of sanctions against Russia.
Fox's Griff Jenkins in western Ukraine. 2 people have been shot at a pipe factory in Anderson, South Carolina, outside Greenville.
Obviously, a very scary scenario, very tragic scenario, and so trying to work through all the details now and begin the investigation.
Anderson County Sheriff Chad McBride says one of the victims was in critical condition. The shooter is dead from a self-inflicted gunshot wound. They've not identified a motive yet. The COVID compromise in the Senate in jeopardy as Republican senators insist on linking the $10 billion in spending to the continuation of Title 42, the federal regulation that permits deportation of migrants who may be infected. Senate Republican leader Mitch McConnell.
There'll have to be an amendment on Title 42 in order to move the bill.
The Biden administration plans to end Title 42 next month, despite warning that could trigger a new wave of illegal immigration. America is listening to Fox News.
Here at Nimitz Towers, we're a large-scale rental complex. We have over 20 employees, and when the pandemic hit, our concerns were people not being able to work, loss of revenue and income. And luckily, due to PPP, we were able to keep all our employees employed, working. We were able to provide services, maintenance, and cleanliness for the building and the operation. Also, the rental assistance program helped us stay solvent during the pandemic and helped us keep the tenants in place.
We're thankful for Congressman San Nicolas advocating for these funds on our behalf in Washington, D.C.
If you have any concerns about any federal issues, feel free to contact your congressman's office.
Thank you for the federal funds. Thank you for the federal funds. Thank you for the federal funds.
Thank you for the federal funds.
Thank you for the federal funds. Thank you for the federal funds.
Paid for with official funds from the office of Congressman Michael F.Q. San Nicolas.
Podcasts.
Marking the 12th anniversary of the Affordable Care Act, President Biden welcomed his old boss back to the White House yesterday.
The stage in the East Room was worthy of a double take.
We just had lunch together, and we weren't sure who was supposed to sit where.
White House officials insist that even though this is Obama's first trip to the White House in more than 5 years, he remains close with the president.
Vice President Biden, Vice President. That was a joke.
There were lots of jokes like that as Democrats try to tell a news story. We didn't hear anything about Ukraine or inflation or immigration from 44 or from 46, but we did hear a lot of talk about the good old days when Barack Obama was president. At the White House, Peter Ducey, Fox News.
The Biden administration expected to announce today it will continue the freeze on federal student loan payments through the 31st of August. That'll extend the moratorium that has allowed millions of Americans to postpone payments during the coronavirus pandemic. Student loan payments were scheduled to resume May 1st. The action applies to more than 43 million Americans who owe a combined $1.6 trillion in student debt that's held by the federal government. Drama in the skies as Air France pilots averted disaster when their jumbo jet malfunctioned as they prepared to land in Paris yesterday.
The Boeing 777 descended to 1,200 feet and stopped responding to commands. But the pilots of Air France Flight 11 successfully landed in Paris, but not before first aborting a landing because they weren't certain they could safely touch down. Audio recordings capturing alarms blaring as the crew struggled to bring things under control. They did a go-around and on the second attempt landed without incident. Gary Baumgarten, Fox News.
And I'm Jack Callahan. This is Fox News.
Half a day. Patsy Gogri from Security Title here with information about what a title company does. The title side of our business determines who owns a property and guarantees your ownership with a title insurance policy. The escrow side acts as an independent third party, managing the transfer of money and documents between the buyer, seller, lenders, and others. Security Title has a management of real estate closings down to a science. Give us a call. We are here to help.
Back at it again with the Lenten season menu with Mezcla, giving you a variety of food you can enjoy and pick from, like the fish tacos, spicy buttered shrimp, parrotfish escabeche, lobster pad capral pasta, crab crusted Chilean sea bass, and more. There you have options. Offered at Hagatna location for lunch and dinner only at Mezcla. For reservations, call 671-479-2652. What are you waiting for? Let's go celebrate the Lenten season with Mezcla.
Here at Nimitz Towers, we're a large-scale rental complex. We have over 20 employees, and when the pandemic hit, our concerns were people not being able to work, loss of revenue and income, and luckily, due to PPP, we were able to keep all our employees employed, working. We were able to provide services, maintenance, and cleanliness for the building and the operation. Also, the rental assistance program helped us stay solvent during the pandemic and helped us keep the tenants in place.
We're thankful for Congressman San Nicolas advocating for these funds on our behalf in Washington, D.C.
If you have any concerns about any federal issues, feel free to contact your congressman's office.
Thank you for the federal funds. Thank you for the federal funds. Thank you for the federal funds.
Thank you for the federal funds.
Thank you for the federal funds. Thank you for the federal funds.
Paid for with official funds from the office of Congressman Michael F.Q. San Nicolas.
Okay, so here we are after that big halftime show that we all have such an affection for. And I promised before the show that I would get into a court case called Carl T.C. Gutierrez versus Guam Power Authority, Government of Guam. And this is findings of fact and conclusions of law that issued from that case on March 28, 2011. Yeah, so it's a while back. And I'll just try to sort out the salient parts of the findings of fact here. On June 6, 2001, Lot 5014, number 1-2-2, one of several properties identified as the GLUP 94 Fawcett parcels, was transferred by the United States of America, United States Naval Government, to the Guam Economic Development Authority, hereinafter GEDA. Plaintiff acquired lot, I'm going to just refer to it as lot 122 from now on. Plaintiff acquired lot 122 from GEDA by quitclaim deed executed on April 20, 2004. It's registered land, originally registered October 28, 1952 by the Naval Government of Guam for and on behalf of the United States, with a current area of 9,004 square meters. Plaintiff hired Frank Castro to conduct a survey of the property. After surveying the property in May 2004, Castro created a map which was approved by the Department of Land Management, etc. And then I go to page 18 of the decision. Despite the allowance of the recovery of damages in some cases where estoppel is presented, the case before this court presents an additional factor. That is, the plaintiff is not the acquiescent owner, but instead is a grantee of the original acquiescent owner. Thus, the court must address the issue of whether a subsequent owner or possessor in interest may maintain an action for damages against the governmental licensee. In one of two United States Supreme Court cases to specifically address the issue of whether the successor in interest of an acquiescent owner could maintain an action for damages against the governmental licensee, and a case nearly identical to the facts in the courts on Guam, called Northern Pacific Railroad versus Smith, an 1898 case. The Supreme Court, in essence, applied principles of irrevocable license to a takings case, thereby where an owner of land with knowledge of facts and without objection permitted a governmental operation to take possession of such land, construct improvements, and operate upon the land at great expense, the owner's grantee or successor in interest could not afterwards bring either an action of ouster or recover damages against the governmental corporation to whom the license was originally granted. Now, this is what this means. The Navy owned the land. The Navy let at the time, probably it was when the Navy was still running the Power Authority, the Navy allowed the power poles to be put in place with the acquiescence of the owner of the property, which was the Navy, right? When the property was then transferred ultimately to Carl Gutierrez, the fact that the Power Authority had a license over the land meant that Carl Gutierrez couldn't claim that his land had been taken. Now, ordinarily, let's say we're dealing with Blackacre and the Power Authority wants to put power lines across my property. They can't just come in and put power poles in the ground and start stringing wire. They have to talk to me, Bob, we want to buy an easement over your land. I ain't selling. Well, much as we don't want to, we'll have to bring an eminent domain proceeding in the Superior Court. They do. There's a declaration of taking. They have to pay me just compensation for what they took, and they build their power line across the land. But in a situation where a landowner allows someone to come along, let's say a railroad, a power line company, a telephone company, whatever, allows someone to build these, to put the poles in the ground, it doesn't say anything about it, doesn't say boo about it. Although there's no condemnation, there's a license created. And there's something called estoppel by license. A property owner can't watch someone come along and put these valuable things on his land, and then when it's all over say, okay, now you got to pay me money. You got to speak up in the beginning. So in this particular case, the case turned on a different matter. But that would have been the law had it not turned on a different matter, that the grantee of the person of the holder of the property that granted the license can't complain. Now, this very well may be the case in some of these situations where the government of Guam took land that the owner of the property stood by and didn't say anything about it. And of course, if I own Blackacre out in the boonies and the government comes along and builds a nice paved road beside my property and infringes, or it creates an incursion into my property, I'm probably not going to say anything because I want to see the road, right? So this estoppel by license means that in that situation, later on, the owner of the land can't come along and file inverse condemnation because he was an acquiescent owner. And not only can he not, but his grantee, the person that buys the property from him or inherits it from him, is in the same situation. So I suspect that there are probably situations like that where the government of Guam came along, used private property without going through the formalities. But if a landowner brought a suit in inverse condemnation, he might not prevail. Another wrinkle is this, that it's called adverse possession. And if someone openly and notoriously occupies your land and does it for 5 years, there's a 5-year statute of limitations, your suit for ejectment or to quiet title is going to be thrown out of court. Statute of limitations. It's called adverse possession. Now, the good news for property owners is that adverse possession does not run against registered land. Something else I have to mention here is, there's talk, the government will go out and took all this land. What we need to do is file a class action. Well, you're not going to be able to file a class action because everybody's claim is different, arises from different circumstances, has different dimensions, etc. Class actions work really well where, as an example, USAA Insurance Company. Are you familiar with that, Jose? USAA Insurance Company. For a long time, they only sold to military officers, but they've loosened up quite a bit. They'll sell to enlisted, family, etc. And it's a mutual company. So a mutual company means that it's owned by all the policy holders. It's not a proprietary company. It's owned by all the policy holders. So in order to be a policy holder, you have to have shares in the company. And the money that the company makes is added to these shares over the years. And USAA was playing fast and loose with the shares of policyholders. One of the policyholders brought a class action, prevailed, and every USAA policyholder got a check in the mail from USAA because their interests were common. They were all the same. They were measurable, and you could deal with them in a class action. But let's say that you had 900 different situations here where the government build roads or build easements or whatever. Every one is different. It's not going to be a class action. So people that are saying, well, you know, my grandfather told me that the government stole that part of our land over there. My gosh, I hope somebody files a class action, and, you know, I'll get another windfall. I just don't think it's going to work that way.
Nope.
Yeah. I saw an interesting post here. Let's see. Robert Hawk is an interesting post, a little off the subject. Jose, do you know when Michael Vaca will be recording his thanks for the federal government radio spot? It's good. Yeah. Let's see. Somebody posted about Cross Island Road. Yeah. Benedoso Tau. My understanding is Aguilar Road, which is Cross Island Road, Route 17, was taken from my family to complete the road to Santa Rita, Familia and Agate Lot. Well, taken from my family. Once again, you know, on Tall Tales, we kind of emphasize precision in the choice of words. That's why I don't have much patience for talking about a return to normalcy. Let's have a return to normality. So I spent a lot of time on this just to make it clear that the fact that the government may have built part of a road over your property in 1970 doesn't mean that all you got to do is talk to your village mayor and you're going to get a check in the mail. It's just a little bit more complicated than that. Okay, next item on the card is a little bit more real property, and this is Andrew Santos versus GWA. And I've told you a lot about certificates of titles and the deputy registrar of titles, etc. And this gets right straight into it, and I'm going to go into a little bit more depth on my own autobiographical experience here. And this is something that ran on Candid on March 23. Government of Guam title official told AG in 2020 that CT, certificate of title, was issued correctly. The government official who issued the certificate of title indicating Cortec owns lot 10184-7 Ukadu, which I refer to as Lot 7, told Assistant Attorney General Jamie Canto in October 26, 2020 deposition that no mistake was made in the issuance of that legal document. The admission is significant as a court battle brought first by Gov Guam through the Department of Land Management. No, brought first by the Director of Land Management as ex officio Registrar of Titles, and then joined months later by the Waterworks, wages against Cortec to take property away from the company. Cortec purchased the property from Yonex in 2015 and has legally recorded mortgagee's deed filed at the Department of Land Management, evidencing its purchase and claim. Then Director of Land Management Michael Bora based the entire lawsuit against Cortec on his assertion that land management erroneously, now this is not land management, this is the Deputy Registrar of Titles, Andrew Santos, erroneously issued a certificate of title to Yonex in 2010, the ownership of which Cortec purchased in 2015. But according to the October 2020 deposition, Bora's own employee and deputy, as you were, deputized registrar of titles. Well, he's not a deputized registrar of titles. He's the deputy registrar of titles. Now, when the news story keeps getting all of these things wrong, you kind of got to wonder. Said he made no mistake when he issued the certificate of title to Yonex, As a matter of fact, he said he was simply following the legal train of deeds. I think he probably said legal chain of deeds, not legal train of deeds. And transfer documents. Quote, I only follow the deeds, the transfer documents, former Deputy Registrar of Titles, Andrew Santos said. I did not go out of no one's way, and I shouldn't. Mr. Canto, who was questioning Mr. Santos, asked him, do you believe that you issued the certificate of title that incorrectly conveyed the treatment plant? Santos replied, man, sir, I would like to say I did make a mistake, but like I said earlier, I only base myself on these transfer documents. There's nothing else that I base myself on but these transfer documents that relate to the conveyance. That's it. The testimony was so damning for the government's case, Canto had to do a double take on the question. Do you realize now that you made a mistake? Canto asked. The question elicited a more damning answer. I want to tell you, I don't think I made a mistake, the issuer of titles said. So let's just stop and take that apart for a second, okay? The fact that the Deputy Registrar of Titles said in the deposition that he didn't make a mistake could be brought before the court as the testimony of Andrew Santos. Is it conclusive? No. It just means that Andrew Santos said he didn't make a mistake. Does that mean he didn't make a mistake? No, it means he said he didn't make a mistake. Okay? I, once upon a time, said that I turned down a job playing center for the Boston Celtics. I said that once upon a time. Was I offered a job playing center for the Boston Celtics? No. Did I say that? Yeah. Big difference, isn't it? I once upon a time, or let me do it this way. It was really a tragedy when Rush died, but after he died, the folks over there at the limbo shop said, Bob, can we hire you to take over for Rush? Okay. Now, let's stop and I'll take a deposition. Bob, did you ever say that you were offered a job to take over for Rush Limbaugh? I said that. Bob, were you ever offered a job to take over for Rush Limbaugh? Hell no, I was never offered that. I just said it. Big difference, isn't there? Yeah. Now, let me tell you a little bit about Andrew Santos. And I've gotten into this a little bit concerning the War of Bishops' Succession. We had a bishop. I'm going to pretend I'm the vice. I'm saying things here, that I want people to pay attention to. I'm going to pretend I'm the vice president. There was a bishop named Bishop Apparon, who was our bishop. His name was Bishop Apparon. And there was this group called the Neo-Catechumenal Way. They were called, anyhow. So the Neo-Catechumenal Way and the Jonia property that became the Redemptus Mater Seminary was a matter of great controversy, because Archbishop Apparon created a paper called a Declaration of Deed Restriction. And that Declaration of Deed Restriction said that property in Jonia, which had been property of the Archdiocese of Agania, could only be used as a seminary for the teaching of the Neo-Catechumenal Way. And the Declaration of Deed Restriction was also was in favor of the Redemptus Mater Corporation. So at the minimum, and it was in perpetuity. So at the minimum, the church could never use that property for anything again, could never sell it, etc. And to add a little frosting on the cake, the Articles of Incorporation for the Redemptus Mater Corporation said that there was a special governor, a board of governors, I think they were called, that all important decisions of the corporation had to be approved by them. There was a couple of Generinis and Pochetta back in New Jersey, the number one guys for the Neo-Catechumenal Way in the United States. The corporation had a board, all of whom were appointed by Apparon, and Apparon was one of the members of the board. So our position was that Apparon gave the land away to the Neo-Catechumenal Way by giving it to that corporation the board on which he only had one vote. So almost 5 years later, Apparon kept this under wraps. No one knew about it. I see an article in the newspaper because there's a contest. Tim Rohr's blog and the Concerned Catholics of Guam have started to make an issue about this, about why did you give away the seminary? And there's a certificate of title published in the Daily News that shows fee simple title in the Archbishop of the Archdiocese of Agana, nothing at all about the Redemptus Mater Seminary in the memorials. So I knew this had to be wrong. So I was off island. When I got home, I asked Andrew, I went to see Andrew Santos about it, and told Andrew Santos this is wrong, because there has to be a memorial on that certificate of title referencing the declaration of deed restriction. Andrew Santos said, yeah. And he had 3 new certificates of title in his hands, and he said, yeah, it's been corrected. I have it here. Who asked you to correct it? Well, lawyers. He wouldn't give it to us that day. We got it the next day. And what it was a certificate of title, and in a memorial in longhand. Very nice penmanship. Andrew's penmanship in longhand. It referenced the subject to declaration of deed restriction, but then it said in favor of the archdiocese. So it went from wrong to wronger. Wow! So I wrote a letter to the Director of Land Management pointing this out, and the Director of Land Management wrote back and said, you're right. He said, I'm going to see if I can fix this. Or actually, when I met with him, he said, I'll see if I can fix this. But then he wrote me a letter, and he said he'd conferred with the Attorney General of Guam, who said the only way you can fix a mistake in a certificate of title is by either the Registrar of Titles, which is Director of Land Management, taking it to court in a suit, or by a person who has interest in the matter taking it to court. So he said it's got to go to court. All right, let's break for the big halftime show, and we'll come back to this.
Pica's best radio station, but we're always looking for ways to be even better. Announcing the point on Alexa. In addition to our FM and HD radio feeds, our incredible app, informative website, Facebook Live, and YouTube Live, you can now tell Alexa to stream The Point. And your smart speaker will start playing whatever we're saying. News and views 24/7 with your 4-word command. Alexa, stream The Point.
The Extra Point with Jerry Roberts of Guam Training.
Hi, I'm Jerry Roberts, and every day on The Ray Gibson Show, I get to comment on the incredibly diverse, fun, challenging, sometimes frustrating, often exciting, but always interesting world of work. I hope you'll be there with us.
You can find daily transcripts of The Extra Point at guamtraining.com. Tune in every weekday morning at 7:20 for The Extra Point with Jerry Roberts, brought to you by Guahan Insurance Services and First Hawaiian Bank on 93.3 104.3 The Point.
Hey, what did the grilled cheese sandwich say to their date?
What'd they say?
You make me melt.
Oh, so cheesy.
But not as cheesy as Subway's latest Eat Fresh Refresh menu innovation. The new Fresh Melts with 3 times the cheese. Fresh Melts are the cheese lover's holy grail. Fresh Melts combine freshly baked breads and your favorite meats topped with a triple load of cheese. All grilled to warm, toasty perfection. Try the ham and cheese melt, tuna melt, or steak and cheese melt to start. Best of all, you can make any footlong into a fresh melt. At Subway, eat fresh.
So Andrew fixed that certificate of title, but he fixed it wrong. You know, so when Andrew says, I didn't make any mistake, I'm here to say Andrew made a mistake. On that one, it was a serious mistake. And it took a long time to correct. Bora's letter said that he had prepared the papers to file suit to fix the certificate of title. It dragged on and on and on. I talked with counsel for the Department of Land Management on more than one occasion in Bora's presence, who said, I got to talk to Jackie Terlahi before we do anything on this. And finally, what happened was that Jackie Terlahi gave the certificates of title to Andrew Santos, and the certificates of title were then amended so that the encumbrance to the Redemptus Mater Seminary showed up not as in favor of the Archdiocese, but in favor of the Redemptus Mater Corporation. So how did that happen? You know, if Andrew really knows what he's doing and knows that he has to do these things only based on the chain of title. One thing I forgot to tell you was that with the Freedom of Information Act, we got the abstract of title that Andrew prepared the day before, finished preparing the day before he issued the wrong certificate of title, and it showed exactly that encumbrance. He just didn't put it on the certificate of title. So you know, if anybody wants to know about Andrew Santos saying, I didn't make any mistakes, I got plenty to tell him. I'm just giving kind of the shorthand rendition of this story. So I don't put any credence whatsoever in his denying that he made a mistake. Now, this story goes on to say Mr. Cantos acknowledged since October 26, 2020, that his own client, Mr. Santos, as the issuer of titles, destroyed the government's entire... Oh, wait a minute. I got to go back here. Yeah, well, I can't find it in here, but I do remember reading that Santos had been fired at the Department of Land Management, but the director entered into a settlement with Mr. Santos, reinstating him with full back pay, agreeing to destroy all of the records underlying Santos's termination. So there's just an awful lot to chew on here. Was Santos fired because he made a mistake? Or was Santos fired because he wouldn't make a mistake? Very interesting. But this whole waterworks certificate of title Andrew Santos, Michael Bora case. And I think there's much more to this case than what meets the eye. A whole lot more to it than what meets the eye or has been reported in the newspaper. And of course, the newspaper can't get anything right anyhow. You know, the difference between a train of title and a chain of title is beyond them. So that leaves it up to Troy to really dig into it. But I hope you do, Troy, because this whole thing about Andrew Santos, if nothing else, causes me to ask a lot of questions. And one of the things that, while we're talking about certificates of title, after we went through this whole certificate of title mess with the Redemptus Mater Seminary, I was tempted to draft up a bill that would abolish this whole system of certificates of title, because it's a useless system, and you can see the problems that it causes, especially when you've got a layman making these multi-million-dollar decisions. It's not a good system at all. If we didn't, and because we, you know, and one other thing about certificates of title, the way it was supposed to work, the way Mr. Torrens invented it, every time you did something to the chain of title, every time you added a memorial to the certificate, every time a new certificate was issued, there was a filing fee. And the filing fee was supposed to be accumulated into a fund. So if there ever were a challenge to the certificate of title that went against anyone who held a certificate of title, that fund would be there to defend the title that the certificate of title evidenced. Well, one of the first things we did after the Organic Act passed was take all the money out of that fund. We don't need that fund. But if the certificate of title mechanism were working the way it's supposed to, there'd be no need for title companies. Because in effect, the certificate of title mechanism insured titles. But it never worked that way. I don't know any place that has ever been given a high grade as being efficient. It's something the Navy dragged along with them wherever they went. But if we didn't have certificate of titles, if we had a statute that said, we're just going to go, on the chain of title like every other common law jurisdiction does, and we had legitimate, ethical title companies here, we'd all be a lot better off. We wouldn't be having this conversation that I'm having right now about Andrew Santos. Okay, so much for Andrew Santos, the Waterworks, Cortec, etc. Next item on the card is Democrats versus Ted Cruz. And this goes back to the confirmation hearings that I'm just now getting to. Before I get into that, I've got a short one here that ran on Jonathan Weissman's column. Demand to define a woman injects gender politics into Jackson's confirmation hearings. Senator Martha Blackburn, Republican of Tennessee, asked Judge Ketanji Brown Jackson if she could, quote, provide a definition for the word woman. Republicans have spent hours this week trying to portray Judge Jackson as an extremist on issues of race and an apologist for child sex abusers. Late Tuesday, Senator Marsha Blackburn, Republican of Tennessee, added another social issue to the list of cultural grievances the GOP is foisting upon her in her confirmation hearings. Gender. Specifically, what makes a woman a woman? An unfair question if there ever were one. Gender rights are dominating outrage on the right after the Republican governors of Indiana and Utah vetoed bans on the participation of transgender women in women's sports in recent days, and a transgender swimmer, Leah Thomas, won a collegiate swimming championship. Ms. Blackburn brought that swimmer up late Tuesday as Judge Jackson's first day of questioning was coming to a close, then asked, "Can you provide for the definition of the word woman?" As she and other judicial nominees before her have done regularly, Judge Jackson dodged the question as outside her role on the bench, saying, "I am not a biologist." This guy thinks that, Blackburn really did something wrong here. It just shows you how successful they've been, Jose, how successful Robert Underwood has been since he began the embrace of critical race theory way back in 1972. He's got us to the point now where so many people have bought into critical race theory that we don't know the difference between a man and a woman, and we're offended if someone even broaches the question. But Blackburn pressed the point and the hot button issue. Quote, "The fact that you can't give me a straight answer about something as fundamental as what a woman is underscores the dangers of the kind of progressive education that we are hearing about," she said. "Just last week, an entire generation of young girls watched as our taxpayer-funded institutions permitted a biological man," and it's a shame that we have to put the word biological. A man is a man. There are not biological men, spiritual men.
Test tube men.
Yeah, test tube men, experimental men. A man is a man. A woman's a woman. Watched a biological man compete and be a biological woman in the NCAA swimming championships. What message do you think this sends to girls who aspire to compete and win in sports at the highest levels? And I know that a lot of women are zeroing in on this. It's not fair to women. That's true. And that's an issue, but it's not the really important issue. How about the girls? How about the women that aspire to be biologists? And if you take Jackson's testimony, even a biologist is not going to be able to tell you, because it's one of those kinds of things that we don't talk about. Social issues that are animating Republican voters, particularly issues of race, are also dominating Republican questioning of Jackson, the first black woman to put forward for the Supreme Court. And she got it on merit, just like Kamala Harris did, right? Yeah. Blackburn's insertion of gender into hearings was not connected to any particular case coming before the Supreme Court. All right, fair game. Or decided by the High Court in recent terms, as is tradition at such hearings. A decision of stare decisis, this was not. So if it's not a litigated issue, there's no reason she can't answer it.
She found one.
It's not one of those, well, that's an issue that may very well come before me if I'm confirmed as a justice. I shouldn't prejudge the matter. The critic here says, it's not that. But it was connected to the politics of the looming midterm elections. At 11 p.m. Tuesday night, the senator's office blasted out an email with the headline, "Breaking, Judge Jackson cannot define the word woman." As they did all day on Tuesday, operatives at the Republican National Committee grabbed on the latest line of social attack on Wednesday morning to amplify Ms. Blackburn's message. I'm so glad that they did. So, so often things like this just get covered up and swept under the rug. Well, if Blackburn is bad, Ted Cruz is just as bad. Yeah. Ted Cruz accused of hate crime for questioning Ketanji Brown Jackson about CRT. He wants to gin up white grievance.
I told you, this is the new thing where they're taking people with Hispanic or Latin descent and calling it the new white supremacy.
That's it. Yeah. So
white nationalism.
For what it's worth, Ted's father came from Cuba. Now this of course makes him a person of color, right? The fact that he came from Cuba, the fact that he has an Hispanic name, and the fact that he probably speaks Spanish. Now, the fact that he's as white as the driven snow has nothing to do with it at all. Senator Ted Cruz was accused of engaging in a hate crime on Tuesday after he questioned Republican nominee Ketanji Brown Jackson about critical race theory. During Jackson's Senate confirmation hearing on Tuesday, Cruz pressed Jackson about her position on CRT, a legal framework that analyzes the intersection of race and the criminal justice system. Cruz questioned Jackson about previous speeches she gave and about the curriculum at Georgetown Day School, where Jackson sits on the board, which Cruz described as filled and overflowing with critical race theory. I wonder if Robert Underwood would have gone to that hearing if someone had paid his way. He's one of the pioneers of critical. 1972 is a long time ago. Regarding the speeches, Jackson said she was referred to CRT when referring a plethora of legal theories and practices. And regarding the curriculum, Jackson said she has no control over what is taught at Georgetown Day School. No control. Meaning she shouldn't even be interested just because her kid goes there. Who accused Cruz of a hate crime? During an appearance on MSNBC, Democrat strategist Chai Komanduri said watching Cruz's questioning was akin to witnessing hate crime. This is about Jackson being a black woman, and this is about basically casting her as a radical, as a black radical who is out to get white people. That is specifically what they're trying to do. Komanduri said, is there a hate crime here somewhere?
Well, it probably identifies as a hate crime.
Yeah, what Komanduri said. Yeah, not what Cruz said.
Not what Cruz said.
Yeah. It's really ugly. Quite frankly, it looked like I saw Ted Cruz commit a hate crime in that hearing room, Komanduri added. It was McCarthyism at its worst.
He can't get his things like straight. It's not McCarthyism.
Yeah. Yeah, and once again, McCarthy. Joseph McCarthy was the junior senator from Wisconsin. Joseph McCarthy was one of the most popular people in the United States, or at least well-known people in the United States, when he said he had proof that the United States Department and other parts of the U.S. government were inhabited by communists. And he went at great lengths to expose these communists, all of whom took objection. And so it was a classic case of the accuser being the guilty party. Problem that McCarthy had, well, I'll come back to McCarthy after we visit Chicago.
Listen to The Point anytime, anywhere on Odyssey. Odyssey is your new audio home for all the music, news, sports, and podcasts that matter to you. Find your favorite stations like The Point and discover more. Music stations, local and trusted news sources, sports talk and team coverage, plus today's biggest podcasts. Find it all on the Odyssey app. AUDACY.
Here at Nimitz Towers, we're a large-scale rental complex. We have over 20 employees, and when the pandemic hit, our concerns were people not being able to work, loss of revenue and income, and luckily, due to PPP, we were able to keep all our employees employed, working. We were able to provide services, maintenance, and cleanliness for the building and the operation. Also, the rental assistance program helped us stay solvent during the pandemic and helped us keep the tenants in place.
We're thankful for Congressman San Nicolas advocating for these funds on our behalf in Washington, D.C.
If you have any concerns about any federal issues, feel free to contact your congressman's office.
Thank you for the federal funds. Thank you for the federal funds. Thank you for the federal funds.
Thank you for the federal funds.
Thank you for the federal funds. Thank you for the federal funds.
Paid for with official funds from the office of Congressman Michael F.Q. San Nicolas.
Okay, here we are on Tall Tales at as you were at Churchill Downs in Louisville, Kentucky. We're on the home stretch of Tall Tales now. I'm just going to spend a couple seconds on Joseph McCarthy. Joseph McCarthy accused a lot of people of being communists, and a book or a expose called the Winona Intercepts proved that he was pretty much right in his accusations. The United States was able to break the code of the Soviet Union during World War II, and they got a lot of really interesting information about people in the United States government who were, in fact, communists. One of whom was a guy named Alger Hiss. If you ever see a picture of Roosevelt at Yalta, Alger Hiss went to prison for perjury. You see a picture of Roosevelt at Yalta, the guy standing right behind him is Alger Hiss. Yeah. And the narrative is that Hiss and the other communists in the State Department were able to persuade Roosevelt into giving Stalin Eastern Europe. And there's a lot more to it. Anyhow, the left rose up and accused McCarthy of making false charges, et cetera, ruining people's lives, et cetera. And that's where the term McCarthyism came from. Now, looking at this in a light most unfavorable to Cruz, how this could be McCarthyism is beyond me. I think I'm going to engage in some hate speech here and say that this guy, Komanduri, doesn't know what he's talking about. According to Komanduri, who worked for Barack Obama and Hillary Clinton's presidential campaigns,
Enough said.
Cruz was seeking to stir up racial animosity against Jackson. He wants to gin up white grievance, him and Marshall Blackburn. Not very good grammar either. The GOP want to gin up white grievance ahead of the midterm and link Judge Jackson to that cause. It's really, frankly, was disgusting and ugly to watch. The Republican National Committee's attempt to paint Jackson as a proponent of critical race theory also generated accusations of racism. So it's bad when the Republican National Committee does it, but when Robert Underwood puts it in a newspaper and points the finger at himself, he wants to be praised for it. In response to an RNC tweet that crossed out Jackson's initials, replacing KBJ with CRT, Representative Sheila Jackson Lee said the GOP had engaged in a racial attack. Shameful. Whoever or whatever provoked this racial attack should be exposed for their divisive, wrong-headed attack, the lawmaker said. Judge Brown Jackson believes in equal justice in America. She is a patriot who loves this country. Stop this racial attack. Enough is enough. GOP starting up their meritless smears.
This is embarrassing. This is embarrassing for Jackson. Because she can't even be judged on her merits because the people supporting her are calling it all racism. Anything that's asked of her is an automatic racist statement.
And unfortunately, that's all there is. How was it that she got appointed to that position?
Her only qualifications was her gender and her external skin color.
Yeah, and because Joe Biden promised a senator from North Carolina that he would appoint a black woman to the Supreme Court. What's his name? I can't remember his name.
Can't remember.
It'll come to me before the end of the show. Yeah, just like Kamala Harris. I'm going to appoint a black woman to be vice president. But there's nothing racist about any of this stuff. Take this word racism and expunge it from your vocabulary, because it's not useful at all when you're talking about the vice president or Supreme Court nominations. Critical race theory is racism writ large. There's just no way to get around it. Even Kenji X, what's his name? Kenji X something or other, with a major proponent, modern proponent of critical race theory, when asked, well, what's the answer? He says more racism. And the more racism is inclusion, equity, and diversity. So we've got to bend over backwards to give those people who are different races than the white oppressors more than what they would get if left to their own devices. It's as racist as it gets. And that's all there is involved here, is nothing but racism.
It's lazy.
And and Biden could have done the same thing if he had kept his stupid mouth shut. He could have said, I'm going to find the best person I can for Supreme Court justice.
What's wrong with that?
Nothing. And then later on he says, I'm announcing Ketanji Brown Jackson. As if I were Ketanji, I would have insisted on that. If you're going to bring in this black woman stuff, cut me out. I don't want any part of it. Okay, I think we're there, aren't we, Jose? Yeah. So it's just about time for me to find my sign here and say those immortal words. Let's go, Brandon.
The Point is KUSG, Hagåtña, Guam, 93.3 FM and 104.3 HD3.
More firepower for Ukraine. I'm Jack Callahan, Fox News. The Biden administration dispatching more armor-piercing missiles.
The U.S. is sending up to $100 million worth of additional Javelin anti-armor systems aimed at taking out Russian tanks. Secretary of State Blinken announced the addition late Tuesday. He says since the start of the Biden administration, the U.S. has given $2.4 billion worth of aid to Ukraine.
Fox's Jill Nato in Washington. The latest shipment ordered after Ukraine's President Volodymyr Zelensky made an emotional appeal to the United Nations Security Council yesterday, accusing Russian invaders of war crimes and lamenting,
if we had already got what we needed, all these planes, tanks, artillery, anti-missile, and anti-ship weapons, we could have saved thousands of people. I do not blame you. I only blame the Russian military, but you could have helped.
Speaking through a translator, President Zelensky called for the Russian soldiers to face a war crimes tribunal similar to Nuremberg. Not so fast on that reported Senate compromise for $10 billion in new COVID funding. All 50 Senate Republicans voted no on a procedural step to move the bill forward yesterday, hoping to tie the spending on vaccines and coronavirus testing to continuation of Title 42, which allows the U.S. to deport foreigners who may have been exposed to disease. Senate Majority Leader Chuck Schumer isn't happy.
There's no reason we shouldn't be able to get this fundamental bipartisan bill just agreed to by a group of Democrats and Republicans passed. It's vital to the future of the country.
The Biden administration plans to cancel Title 42 next month. The Omicron BA2 variant, now the most common form of the coronavirus in the U.S., but here comes another. A new variant known as XE has been identified